Good evening, everyone. I'm Ankit, and you're watching the Indian Express analysis, which goes live every day at 4 p.m. on StudyIQ IS English channel. Today is 18th of April, and we are going to discuss important news and articles that I've picked up from the, as usual, Indian Express newspaper. Now, the first article is a very good article about Article 142. Why this is a news? Because Vice President of India, Mr. Jagdeep Dhankar, actually termed use of 142 by Supreme Court of India as a nuclear missile. So what does actually 142? What kind of powers does actually 142 gives to the Supreme Court? All of this we are going to discuss in our today's discussion. Also, this kind of important provisions like Article 142, Article 19, Article 21, Article 32, all of them in one form or the other have been asked in the prelims examination. So, whenever such important provisions of the Constitution are in news, automatically they become important from our exams perspective. So, this deals with the GS paper 2 perspective, particularly the polity aspects of the syllabus. Today, most of the articles, at least 3 articles are related to the polity, so we are going to discuss all of them. Next article is that a Supreme Court judge, Justice Gavai, has been nominated as the next Chief Justice of India by the outgoing Chief Justice of India. So what is the process through which the Chief Justice of India is selected and appointed by the President? We will try to understand in our today's discussion. Also, matters dealing with appointment of judges to the High Court and Supreme Court is very important, as we have dealt with earlier also, that is in the collegium system. But now this designation of Chief Justice of India of an already existing judge of Supreme Court is somewhat different. So that we are going to understand in our today's discussion. This also is relevant from GS paper 2 perspective, particularly with respect to structure and functioning of judiciary. Third article is about Asola Bhati Wildlife Sanctuary that is located in Delhi, because yesterday a leopard was spotted in this particular wildlife sanctuary. So this wildlife sanctuary becomes important. Also, this is the only protected area in whole of Delhi. That is why this becomes important, particularly from the UPSC perspective. Now, this again is relevant from GS paper 3 perspective, that is important protected areas, be it national park, wildlife sanctuary, tiger reserves, all of that becomes important. Then we'll be understanding about Silkyara tunnel. Silkyara tunnel is actually a tunnel located in Uttarakhand. This was in news last year actually, because many workers, they were trapped, at least 41 workers, they were trapped in this tunnel for about 17 days. Now government did everything it can and they rescued them alive. So that is why this tunnel was in news. Now this is in news today because the breakthrough of this tunnel happened. What is breakthrough? I'll tell you everything. Now this tunnel, it deals with place in news. That is why important from our exams perspective. Then we'll be understanding about Tensor processing unit. Now Tensor processing unit has been unveiled by a company called Google. So how is a tensor processing unit different than central processing unit and graphic processing unit? All of this we are going to understand. What are the use of such tensor processing unit? We'll also get to know in our today's discussion. In the end, we'll be understanding the often quoted Waqf Act, because this Waqf Act currently is challenged in the Supreme Court. That is the legality of this act passed by the Parliament. Now, upon hearing the petition challenging the legality of this act, Supreme Court has highlighted few provisions of this act as a key issue, and it is likely that going forward, whenever Supreme Court comes up with its decision, it might stay implementation of such contentious provisions. So we are going to revise Waqf Act, particularly the issues that has been considered by the Supreme Court right now when the hearing is going on. This again is relevant from GS paper 2 perspective, particularly from the polity aspect of syllabus, right? So 3 articles are from GS paper 2, 1 is place in news and 2 are from GS paper 3. That is why these are the articles that we are going to discuss. Now, as usual, the notes for this session will be available immediately after the class ends. This note, you can download it on my Telegram channel, ETS Live. So you can either search it on the top right hand corner of your app, or even if you don't want to do that, you always have a QR code to scan, like the money you pay. You can scan this QR code. Here you will not be required to pay any money. These notes are available free of cost for everyone who subscribe to my Telegram channel. Okay. Now, let us get started with our discussion. Sarang, Achal, Augustine, Blueberry, Bhanu, Baga Springs. Good evening, everyone. Hi to Blueberry, not good evening to you. Yes. Now, as I was saying, this is the first article of the day, appeared on the very front page of the Indian Express newspaper, and it quotes the Vice President Jagdeep Dhankad, who has taken a swipe at judiciary, saying that it can't direct what the president can and cannot do, and it also can't act as a super parliament by using the extraordinary provision provided to it under the Indian Constitution known as Article 142. So that is why we are going to discuss Article 142 today. Now, why is Article 142 in news these days? Because Supreme Court about 2 weeks before, it actually overruled the decision made by the governor of Tamil Nadu. Now, what Tamil Nadu governor was doing, he was not giving the assent to the bills that have been passed by the Tamil Nadu state legislature. And these bills, almost 10 of them, they were pending for a long period of time without becoming an act, because to become an act, a bill needs to be signed by the governor, and this process is known as giving an assent, which was not given by the Tamil Nadu governor. So naturally, this matter reached the Supreme Court of India, and Supreme Court gave a very extraordinary decision. It used the power of Article 142 to give its approval on providing the assent to the bills, that even if the governor had not signed the bill to make it an act, the Supreme Court used its power to 142 to deem that the assent by the governor has been given. So this use of power by the Supreme Court under 142 article is in news because of this provision only. Now let us understand the context of this article. In the wake of Supreme Court ruling that it gave against the government of Tamil Nadu versus the governor of Tamil Nadu, that it set a 3-month timeline even for the President of India to decide on bills which is referred to it by the governor for their consideration. So in that regard, Vice President Jagdeep Dhankad has said that judiciary can't direct the president what to do, because passing a bill is actually an executive function of the president, whereas judiciary, which is an altogether a different organ of the state, it can't direct president what to do in this particular regard, right? Similarly, Vice President said that use of Article 142 by the Supreme Court to pass any order necessary to ensure complete justice in any case pending before it has become actually a nuclear missile with the judiciary to use it against the democratic force. Why was he using the term democratic force? Because essentially passing of the law, it is an essential function of the legislature, whereas implementation of the law, it's the responsibility of executive. So this is what the legislature and executive are meant to do. Judiciary, what they are required to do is to check the legality of the law, not to go beyond its responsibility and direct legislature and executive what to do and what not to do. So this is the opinion of Vice President regarding Article 142, that it is indeed an extraordinary power, but it can't be misused by Supreme Court of India, right? Now, in this regard, let us understand what is Article 142. Now, if you read Article 142, you'll judge from the text that it is actually a unique power provided to the Supreme Court of India to ensure that complete justice happens whenever there is a dispute between two parties. Now, there might be a scenario when there is no particular law to regulate or to highlight how that disputes will be solved. So in that case, there is a legal void in certain cases. So to allow or not to allow these legal void to ensure injustice, Supreme Court ensures that this legal void is filled with its own intervention under Article 142. So in doing so, Supreme Court can extend itself to put an end to dispute. Suppose if any dispute is happening, Supreme Court is saying, what is happening? They say this is not going to solve. Supreme Court said, wait, come to me, I'll solve it for you. So this is basically what 142 is. But the fact is, under 142, Supreme Court can do anything. Case in point, I'll give you certain examples in our today's discussion only. Now, Supreme Court in this exercise of its jurisdiction may pass certain order or make such an order so that it ensures that complete justice happens. For example, there was this very famous Vishakha guidelines that were issued by Supreme Court to deal with matters related to sexual harassment at workplace. Why Supreme Court actually intervened in this case? Because there was no law passed by the either Parliament of India or any state legislature to deal with any cases relating to sexual harassment of women at their workplace. So Supreme Court understood when there is no law, how can actually justice happen? So it passed certain guidelines. Now they are called as Vishakha guidelines, which dealt with whenever the sexual harassment should happen. So after these Vishakha guidelines were passed, then only the Parliament of India passed a particular act known as Prevention of Sexual Harassment at Workplace Act of 2013, right? So this is how Article 142 works. Whenever there is a legal void, whenever there is no law to deal with certain matter, Supreme Court intervenes it. So this is the ideal way of how to use Article 142. But is Supreme Court using Article 142 in this regard? Let us try to find that one out in our today's discussion. Now, first, let us understand why is such a power given to the Supreme Court of India under the Indian Constitution. First, by giving such power, it actually enables the Supreme Court of India to exercise whatever is known as executive functions and what are known as legislative functions. What is a legislative function? To pass a law. And what is the executive function? To implement a law. So whenever these two organs are not doing whatever they are required to do, in that case Supreme Court can take it upon itself to do such a function, that it can decide to enact any order which effectively becomes a law of the land, and it can also pass such a judgment that effectively becomes implementation of the law. For example, in 2015 or 16, I am not able to recall the year, there was this cess that were implied on the diesel vehicles more than 2000 cc's in their engine capacity. So that extra cess meant that Supreme Court actually used its power of Article 142 to impose taxation on diesel vehicles. Now, what is taxation? It is actually a unique function of legislature, that only legislature can pass or can actually approve certain taxes that are levied by the government. So in that case, Supreme Court used its extraordinary power to impose taxation. Now, whether this is right and wrong of Supreme Court using such a power that way, it is altogether a different discussion, right? Now, it has in many cases issued guidelines, directives, and even ordered to governmental bodies and other authorities to do such a thing. That, for example, Vishakha guidelines I told you, right? Vishakha guidelines, it issued a guidelines that dealt with prevention of sexual harassment at workplace because there wasn't any law in the place. Also, it permits the Supreme Court to intervene in matter which concerns public interest, which concerns human rights, which concerns constitutional value, which concerns fundamental rights, effectively to ensure that they are not violated by anyone. For example, you may have heard about Article 262, right? What does Article 262 provides? It provides that whenever two states in India, they are disputing over sharing of river waters, that matter has to be resolved by a special tribunal which is created by the central government. And this is according to Article 262, which provides or which has enacted Interstate River Water Dispute Act. So, whenever there is a dispute between two states regarding sharing of river water, they ask center to constitute a tribunal, and whatever decision the tribunal gives, it is final and binding on both of the states. And here, any court in the country, even Supreme Court, can't intervene. So, this is what Article 262 and Interstate River Dispute Act says. But Supreme Court, in the judgment passed by the tribunal for the Kaveri share of Kaveri river water, Supreme Court actually intervened and it changed the order given by the tribunal which was created under the Interstate River Water Dispute Act. And why did it so? So as to ensure public interest, particularly to the public living in big cities, so that they need water and they can't go without water, right? So this is how Supreme Court ensures complete justice even in matters relating to public interest. Similarly, what is the role of the judiciary, particularly Supreme Court in India? Supreme Court of India under Article 13, Article 32, it is essentially the protector of the Constitution. It has the power to conduct judicial review. So whenever any law passed by the legislature or whenever any act passed by the or any act done by the executive, it violates fundamental rights of the land, it violates your fundamental rights, then in that case Supreme Court can actually review that particular law. And in many cases when the law violates the fundamental rights, Supreme Court actually makes this law unconstitutional and void. So this actually gives the Supreme Court the role to play as a guarantor or the protector of the Constitution. So while ensuring complete justice under Article 142, Supreme Court ultimately proves that it is the interpreter of the law, serving as a catalyst for judicial activism and innovation also. What is judicial activism? Whenever Supreme Court goes beyond what its original responsibility to ensure delivery of complete justice. So this is what is the need or what is the rationale for Article 142 in the Indian Constitution. Now, is this power infinite? Actually, in the words of the constitution it is, but you'll see from the many judgments passed by the Supreme Court that it has actually limited the scope of the use of Article 142. Case in point, there was this judgment passed by the Supreme Court in the Supreme Court Bar Association versus Union of India case back in 1960s, and in that case Supreme Court said that the powers under Article 142 are only supplementary in nature. What do you mean by supplementary in nature? That it acts as a additional power in addition to whatever law has been passed by legislature or whatever decision has been done by executive. So it is not a contravening or a superseding law, it is just a supplementary law, so as to ensure justice happens in the country, right? So it can't be used to replace or override any law passed by the parliament according to Supreme Court, and it is to build a new, it can't be used to build a new edifice where none existed earlier, right? So this is the, according to Supreme Court, that it can't replace the law passed by the parliament. It can only be done in the cases law is silent on particular matters like protection of women at their workplace from sexual harassment, right? Similarly, order passed under 142 must be consistent with fundamental rights that are guaranteed in the Constitution and cannot contravene the right to constitutional remedies that are given under Article 32. So, Supreme Court technically can't use its power under 142 to prevent anyone from reaching the Supreme Court in case their fundamental rights are violated. Similarly, Supreme Court can't prevent or can't deny any people their right to life just because it is given in the fundamental rights, right? Similarly, this provision can't be used to achieve something indirectly which can't be achieved directly, right? So this is what Supreme Court has said, that this power actually is not infinite. It has limited the use of such power by highlighting that it can't override the law passed by parliament, it can't override or contravene fundamental rights, and it can't achieve something indirectly if it is prohibited directly. Also, exercise of 142, according to Supreme Court here, it should ensure that no injustice should be caused to a person who is not a party to the case, right? So, in case it was changing the verdict of the Kaveri Tribunal, Supreme Court issued that it does not affect the supply of water to people living in other states who are dealing with waters of Kaveri, right? So, this is how this act or this part is meant to be used. But naturally, there are many issues with the use of Article 142. What is the issue? Let us try to address them one by one. First is the subjectivity in the definition. Now, if you look at Article 142, it says complete justice. Now, what is justice? Actually, when you highlight the idea of justice, the concept of justice differ from one individual to other. For you might be, justice is actually eye to an eye, or taking an eye for a criminal, right? For example, if I commit murder, so what is a justice to you? Someone should commit murder to me, right? But for another one, that should also mean that if I commit a murder, I should be reformed to a particular person and I should not, or the state should not end my life, right? So therefore, the concept of justice differs according to the individual. So when what is complete justice, it is not mentioned in the Constitution, just the word is mentioned, to it can't be, or it can be interpreted differently by different judges. That is why you'll see in practice there is lack of consistency when it comes to application of Article 142. Sometimes petitioners have approached the Supreme Court that they should consider or pass any direction according to 142. Supreme Court has said no. Sometimes even in the case like recently we saw, Supreme Court actually went way above its means to ensure the delivery of complete justice. For example, it in way deemed that the governor has given an assent to the bill even when the governor has not in reality given the assent to the bill, right? So that is why application of Article 142 have been inconsistent by Supreme Court. Similarly, whenever there is a concept of government or whenever there is a concept of constitution enacted in the country, it meant that it gave certain powers to different organs of the land, right? For example, legislature was given the power to pass the laws, executive was given the power to implement the laws, and judiciary was given the power to review the laws, right? So there is definitely a separation of power even remotely that is envisaged in the Constitution of India. But when Supreme Court using its power power under 142 actually you passes the law or actually implements a law, this actually violates or blurs the concept of what is known as separation of power, right? So therefore this is also a big issue, that what expertise does Supreme Court have when it comes to implementation of any policy? No, right? It is the responsibility of bureaucrats with an oversight of the political executive. So when Supreme Court does not have any expertise when it comes to the execution of the land, so how can it be effectively execute any particular policy? So this is how blurring of lines between branches actually tilts the balance of power in favor of judiciary away from legislature and executive. Similarly, you understand the members of legislature, that is MPs and MLAs, they are elected by you, they are elected by me. Similarly, from MPs and MLAs only you pick out Council of Ministers. So eventually Council of Ministers are responsible or accountable to whom? They are accountable to legislature. Members of legislature, they are accountable to whom? They are accountable to people like you and I. But who are judges accountable to? Judges do not have to answer to legislature. Judges do not have to answer to public. Judges do not have to answer to executive. So when it comes to ensuring accountability of judges, this is actually absent in the Indian judiciary. So when judges or judiciary, they are implementing the laws, they are passing the laws, they will not be accountable. So can you ensure, or can you ensure in a democratic setup that ensuring or executing such a power without any accountability is right? No, right? So that is why this is a big issue when it comes to implementation of Article 142. It is given to the Supreme Court to ensure complete justice, but the application of complete justice is somewhat inconsistent. Also, while doing so, we have seen that Supreme Court actually went above and beyond it means to ensure that it pass the law, or sometimes it can even implement the law, that we have seen in many circumstances, right? I hope I've made everything clear. Now, if it is clear, let's see if you are able to solve this PYQ that appeared in 2019. I will get out of the way, otherwise someone will comment, sir, you did not get out of the way, so I did not able to see the question. Irrespective of the fact they don't know that, please go to the Telegram channel and download the notes. Good evening, Sheetal. Happy Kaizen. Good evening. GK Edits also, good evening. What is the correct answer? Only Baga is answering. Yes, option B is the correct answer. Yes, Sarang, you are also right. Now, moving to the next article of the day. This appeared yesterday in the newspaper, but as you can understand, yesterday we did not have time, so I am taking this article today. Now, this article states that Justice Gavai will be the next Chief Justice of India. And how he has been recommended as the next Chief Justice of India? He has been recommended by the existing Chief Justice, Mr. Sanjeev Khanna, to be formed or to be appointed as the next Chief Justice of India, and he will be the 52nd Chief Justice of India. Now, what is the process of appointing the Chief Justice of India? Now, if you read Article 124 of the Indian Constitution, you will see that this Chief Justice of India is to be appointed by whom? It is to be appointed by President of India. Now, how is any person selected to be Chief Justice of India? The answer is the Union Law Ministry. Whenever the existing Chief Justice is expected to be retired, Union Law Ministry, they ask that outgoing Chief Justice, please recommend us the name who will be the next Chief Justice of India. And in doing so, the Chief Justice of India actually recommends the name of the senior most judge of the Supreme Court by convention. So after the receipt of this recommendation, what the Law Ministry does, that it forwards the recommendation to the Prime Minister of India, and Prime Minister of India advises the President of India that, see, this name has been recommended by the outgoing Chief Justice as the new Chief Justice, so please appoint this person as the next Chief Justice of India. Now, there is no law in the land that says that senior most judge should be appointed as the Chief Justice of India, but it is a convention that has been followed by the Indian judiciary, that the most senior most judge of the Supreme Court after the existing Chief Justice will be next in line to be called as the Chief Justice of India. Has this convention been broken? The answer is yes. This convention has been broken 3 times. First in 1964 when the senior most judge was very ill, so he could not take the office, so the other person was appointed, and the next 2 times were in 1973 and in 1977, and both of this happened when Mrs. Indira Gandhi was the India's Prime Minister. Now, what Mrs. Indira Gandhi did in 1973, she superseded 3 senior most judges of the Supreme Court and appointed the 4th senior most judge, Justice A.N. Ray, as the next Chief Justice of India. Similarly, in 1977, she superseded Justice H.R. Khanna, who was the senior most judge, and appointed Justice Beg as the new Chief Justice of India. So, she has actually betrayed this convention twice by not appointing the senior most judge of the Supreme Court as the Chief Justice of India. Now, this decision by then government actually created a lot of tension between judiciary and executive, which we know actually led to passing of 3 judges case, which led to the formation of collegium system, which we have already covered in our today's discussion, or in our discussion. Okay. Now, the constitution, it does not provide minimum age or qualification or minimum age of qualification for the Supreme Court judges. So, what does actually the constitution says who can be appointed as Supreme Court judges? That is given in Article 124. Now, if you read Article 142, it's subsection 2 of 124. It says that any person who is citizen of India or have at least 5 years of experience as a judge of High Court or 2 or more High Courts in succession, has been an advocate in High Court or 2 or more High Courts for at least 10 years and or maybe a distinguished jurist in the opinion of President, these persons can be appointed as the Chief Justice or as a Justice of Supreme Court. Now, what you have to remember that these conditions are applicable even in the case of High Court judges, but this is not applicable for High Court judges. That a distinguished jurist can be appointed as the High Court judge, but they can be appointed as the Supreme Court judge. So, once you are appointed as the Supreme Court judge and you serve for some years, and if you are the senior most judge in the Supreme Court after the existing Chief Justice of India, you will be next in line to be called as Chief Justice of India, right? So, let's see if you are able to. So, let's see if you are able to solve this question. Yes, Baga Spinks, Mrs. Indira Gandhi broke it. Indira Gandhi was my government, my choice. Yes. Good evening, Saujanya. We see you very rarely, Saujanya. I hope everything is all right at your end. Now, the Chief Justice of India is appointed by the President of India under Article 124(2). Yes, correct. The Constitution mandates that most senior most judge of the Supreme Court must be appointed as Chief Justice. Now, there is no mandate in the Constitution of India. Rather, it is a convention that has been followed by the judiciary to appoint senior most judge. The Union Law Ministry forwards the outgoing CJI's recommendation to the Prime Minister, who in turn advises the President. Third one is right. First one is right, second one isn't. Therefore, option C is the right answer. Sarang, Baga, Bhanu, Sheetal, Aanchal, Reshma, Shweta, all of you are right. Now, moving to the next article of the day. This actually says, like National Geographic Channel or Discovery Channel, that leopard has been spotted near watering hole in Asola Bhati. Now, what is important? Leopard drinking water or the wildlife sanctuary news? Obviously, wildlife sanctuary news. That is why we'll be dealing with the Asola Bhati Wildlife Sanctuary. Now, if you read the context, the Delhi Forest and Wildlife Department yesterday reported a fresh sighting of a leopard at Asola Bhati Wildlife Sanctuary, which is city's lone wildlife sanctuary located near Tughlakabad district of Delhi. Now, the leopard was spotted drinking water from a water hole in the afternoon. Now, what is Asola Bhati Wildlife Sanctuary? It is a protected area in Delhi, which is located in the South Delhi ridge of Aravali Hill Range. Now, if you have taken a look at the map, the Aravali Hill Ranges originates from Rajasthan, enters into Haryana and also ends in the Delhi in the South Delhi region. And this is where this protected area is located, very near to Delhi-Haryana border, but this protected area is located just in the vicinity or in the geographical territory of Delhi. It does not extend to Haryana. Now, the sanctuary, it is a part of Southern Ridge and has biodiversity significance because it is where it merges with the Indo-Gangetic plain. So actually two very significant biodiversities, Aravali Hill Range and Indo-Gangetic plain, they meet at the Asola Bhati Wildlife Sanctuary. Now it is an important part of North Aravali Leopard Wildlife Corridor, which starts from Sariska National Park in Rajasthan and it passes through various districts of Haryana and finally meets in the Delhi Ridge. So that is why it is a leopard wildlife corridor. So spotting of such a leopard is not a big hue and cry in the state of Delhi, because you expect leopards to be there, right? Now let us understand what is the flora and fauna that is present in the region. Now in terms of vegetation, the vegetation that is primarily dominant in the Asola Bhati Wildlife Sanctuary, it is of northern tropical thorn forest type. Now these thorn forest types are the forest types that actually develop in water stressed areas, right? So that is why these kind of plants, they exhibit what is known as xerophytic or xerophytic adaptations, which makes these plants use water at the minimum level and also conserve the moisture within them, right? So therefore you will see they have thorny appendixes, wax coating on their leaves, succulent in terms of root, and tomatoes leaf, which means they are adapting to the water stress environments and also preserving or conserving the moisture that is present inside the body of the plant, right? So that is why xerophytic adaptations you will see in the thorn types of forest. Now in terms of flora, the kinds of trees that are prevalent in the region is neem, peepal as well as jamun, and in terms of fauna, this is home to common mammals like nilgai, Indian porcupine, Indian hare, Indian grey mongoose, and the sanctuary has over 200 species of birds, which includes Indian peafowl, red jungle fowl as well as Indian grey hornbill. Now Indian grey hornbill is a very common bird that is available in Delhi, and the protection status of this bird is least concern. So please remember that it is not a threatened species per matter, right? Now let's see if you are okay. Sojanya, good holidays for my children. Okay. One of the perks of being a child is that you get holidays, which we adults don't. And sometimes even the national holidays fall on Sunday, so what can we do? Or even the judges gets vacation, right? So sorry to that. Children's and vacation, children's and judges, they get holidays, not us. Now, with reference to Asola Bhati Wildlife Sanctuary, consider the following statement. It is situated in South Delhi Ridge of Aravali Hill Forest and forms the part of Northern Aravali Leopard Wildlife Corridor. This is correct. The sanctuary lies in an ecotone where Aravali Hill systems merges with the Indo-Gangetic plain, giving it a high ecological significance. Now, you understand what is an ecotone? Ecotone is an area which is a meeting point of two different biodiversities. So, in that ecotone, you will see the characteristics of both biodiversities, right? Now, this sanctuary is known for its wetland ecosystem and mangrove vegetation. Obviously, this is incorrect, which means they exhibit what? Thorn types of forest, not wetland ecosystem and mangrove. Wetland and mangrove are majorly present in near the coastal areas or where the water is quite prominent or dominant, right? So, option A is the right answer. Baga, Sarang, Amar, Achal, Bhanu, Reshma, Sheetal, Priyal, Reshma, all of you are right. Yes. Now, environment is a very important subject when it comes to its weightage in the prelims examination, right? So, whenever any protected area is in use, we cover it in our exam, in our daily discussion, right? But what about the concepts? What about biodiversity? What about ecotone? Suppose if you're not understanding these terms in our day-to-day discussion, the probability is that you have not attended a particular class for the subject, right? So if any of you face such kind of a problem, you have an option to enroll for April morning batches, which actually provide you with foundation level lecture for all the subjects that are relevant for UPSC exam, and here you will be provided with teaching that is relevant from prelims, mains as well as interview perspective, right? Now the admissions for the foundation April morning batch are ongoing, and you can get the diamond course which has all the benefits of the StudyIQ platform. That is available at 34,999, right? How to get this course or how to enroll for this course, if you may ask, you can go to our website, create an account and then click on explore courses. When you click on explore courses, there will be a tile which will be appearing in your screen which says here, click on UPSC IS English, because I understand most of you are not having the Hindi language as your mother tongue. So in that case, if you want to get yourself enrolled in English batches, please click on this tile and opt for this first tile that says Foundation 2026 April morning English batch. Now is April 2025. You will be giving prelims next year in May 2025. So this is the opportune time for you to get admissions. Now if you look at this, it says 41,999, but let me tell you a way where you can get discounts on this amount, right? You must be watching a ticker flashing on the bottom half of a screen that says use the code ATS live. You have to do that. How to apply that code? Let me tell you. Now here on the right section, you'll see that you are asked to add a promo code. Click on enter coupon code and write ATS live. As soon as you click on apply, you'll see that the discounts are available. Maximum discount of 7,000 is applicable for diamond courses. Similarly, discounts for platinum and gold courses are available, but the maximum discount is available for diamond. Then the diamond course after discount is available at 34,999. You'll get this amount only after you apply the code ATS live, right? So please remember doing that. Coming back to our discussion, let us move to the next article of the day. This also appeared in yesterday's newspaper, and this actually is an image on the very front page of the Indian Express newspaper, and it talks about breakthrough at Silkyara. Now, Silkyara is actually a tunnel located in Uttarakhand, and this was in news last year in 2023, because in 2023 a wall collapsed in this particular tunnel, led to entrapment of 41 workers, and it took the state government, it took the central government, it took our armed forces about 17 days to rescue these people from this tunnel. So that is why this tunnel was in news. Now the breakthrough of this tunnel has happened. What is breakthrough? Now suppose there is this mountain and you have to construct a tunnel. So what happens that machines enter or start to dig up the tunnel from here, and machine starts to dig up this tunnel here, and somewhere in between both of these machines meet, which means the tunnel is now complete. So when these two machines meet, or it leads to final construction or opening of the tunnel, that is known as the tunnel breakthrough. Okay, so this is the term used to see when meeting of two ends of the tunneling from the excavation site, that is called as breakthrough, and this breakthrough has happened, so that is why it is in news. It is not a rat hole mining method. Well, the tunnel has many meters in diameter. Have you ever been in a tunnel for metros, be it in Delhi or anywhere? You'll see that tunnel is so huge, it takes big machines to dig through that amount of land, and this is quite a lot sensitive and quite a lot difficult when it comes to digging up a tunnel in a mountainous terrain, because there the terrain is quite difficult to bore through as compared to the normal terrain available in cities, right? Now let us understand few details about this tunnel. Now it is located on Yamunotri National Highway in Uttarakhand's Uttarkashi district. Now this tunnel will be a part of Char Dham all-weather road projects. What is a Char Dham? Char Dham are actually famous religious centers located in the state of Uttarakhand. These are Yamunotri, Gangotri, Badrinath and Kedarnath. Now earlier approaching these sites were quite difficult because these are located at a very high altitude deep in the Uttarakhand. So what government did? So as to ensure that more tourists reach these spots, more pilgrims reach this spot, and it is good for them and it is comfortable for them to reach this spot, government is undertaking creation of infrastructure. Majorly, it is creating road infrastructure to connect all these major Char Dhams into it, and this tunnel is part of that project only. It is a 4.5 kilometer double lane tunnel which will be the largest tunnel in the whole of Uttarakhand. Upon completion, it will reduce the distance between Gangotri and Yamunotri district by 31.5 kilometers. So what you have to remember that this reduces the districts between two places among four Dham places, that is Gangotri and Yamunotri. So there might be a question in the prelims that says X tunnel connects these two cities, Y tunnel connects X and Y cities, right? So that is how you approach these kind of facts. Now in 2023, a section of the tunnel collapsed where 41 workers were entrapped for 17 days. So this I have already told you, right? Now let's move to another article of the day. This article appeared in the website of the Indian Express. I actually read this article many days ago, about 2 to 3 days ago, and I was expecting it to come in the newspaper so that I will cover for you guys, but it did not cover in the newspaper. So regardless, I am taking the screenshot from the website and explaining to you this is an important article. Now what this article tells us about is that Google has recently launched Ironwood, its 7th generation tensor processing unit. So you might have heard about CPU CPU, that is central processing units, available in our mobile phones, available in our laptops. Similarly, whenever we discuss about AI, you might have heard about GPUs, that is graphic processing units. Someone of you who might be interested in gaming, they also may have GPUs in their laptops or computers, right? So these two are in use. But what about TPU? How is TPU different than CPUs and GPUs? Let us try to understand this, okay? Now, TPUs are actually application specific integrated circuits. Now, there is a concept called machine learning. What is machine learning? Machine actually takes up a large amount of data. It understands the pattern of this data and gives you certain commands according to the, so it is the ability of machine to interpret and learn from the data, that is called as machine learning. Now, it is a capability used in AI also, right? And also in data processing and data science. So, to handle operations that involve huge amount of processing of data, particularly for machine learning processes, you require a different kind of processors, and that are TPUs. So these are application specific integrated circuits which are designed exclusively for accelerating what? Accelerating machine learning task, right? So it is a very specific use case. It is used exclusively for accelerating machine learning. So please remember that GPUs are used for gaming, GPUs are used for graphics, GPUs are used for AI. CPUs are used for general processing, like in your laptops, like in your mobile phones. Now, what are the key features of TPU? TPUs are designed essentially for machine learning, which are optimized for tensor operations, and these are foundation of neural networks. Now, neural networks are actually the networks which is designed by the machine learning itself. So, using the neural networks, machine actually decides how to give certain kind of outputs. Similarly, these are designed for high performance. Now, TPU offers significant faster computation compared to GPUs and CPUs when it comes to performing tasks related to machine learning. Now, training of GPUs to interpret certain machine learning tasks, it might take weeks, but it can be completed in few hours by using TPUs. So that is why TPUs have a very specific use case, and also they exhibit a parallel processing capability like GPUs. TPUs, they also possess the use of parallel processing even, but they are more specialized, that they can handle millions of tensor operations simultaneously, and energy efficiency also, they are more energy efficient than GPUs and CPUs when it comes to running on the machine learning workloads, right? So these are the features of the TPUs and GPUs. Now, quickly let us understand the difference between these three terms. The purpose for CPUs is general computing. The purpose for GPU is for graphics and parallel computing, used mostly in gaming, used mostly in AI, whereas TPUs are used for machine learning specific tasks. Whereas the processing done in CPU is sequential. In GPUs and TPUs, they are both parallel. But TPUs, the processing is mostly for tensor based, which is used for machine learning. Whereas efficiency in AI is low for CPU, is high for GPU, and it is very high for TPU, right? So that is the difference between all these three terms. Now let's see if you are able to solve this particular question. See, seems right नहीं एग्जाम में seems right से काम नहीं चलेगा. You have to know what is right and wrong. TPUs are a type of application specific integrated circuit developed specifically for accelerating machine learning tasks. Obviously correct. TPUs can perform general purpose computing tasks more efficiently than CPUs and GPUs. TPUs are optimized to handle tensor operations which are fundamental to neural network computation. Third one is correct. Second one is not. It is performing a specific task, not a general computing task. Okay. So general computing tasks, CPUs and GPUs are more oriented. For specific tasks, that is machine learning, TPUs are more oriented. Therefore, second is incorrect. Third one is and first one is right. Therefore, option C is your right answer. Baga, Sarang, Aanchal, Saujanya, Bhanu, Sheetal, Priyal, correct. Reshma, please read the question again. I guess you have gotten it wrong this time. Now moving to the last article of the day, I know we have done this many times, but this article appeared in today's Explain newspaper, so there is no harm for us to revise these important topics. Now what this article highlights, that right now there are many petitions, as many as 65 of them, which have challenged the validity of the newly passed Waqf Act of the Parliament. Now this act actually was passed by the Parliament, however there were many opposition also for this act. Now they have a judicial recourse left, that they can file a petition for the Supreme Court saying that we feel this and this provision of the act is actually unconstitutional, so why don't you discuss or declare it unconstitutional. So whenever the Supreme Court was hearing this petition, it has deferred it interim decision based on the fact that it has sought the centre's opinion on the matter also, that what it is doing in that matter. Now centre has sought time to file an affidavit defending the law, but it has assumed that court it will not till the time the next hearing will it. So the centre government has said it will not implement this law until the court decides, right? So what are the contentious provisions on the law based on which the hearing is going on in the Supreme Court? First, and probably the most contentious part of this act, is the doing away of the concept of waqf by use. Now earlier, if a property was used for religious or charitable purposes for a long time, it was determined that this property is a waqf property, irrespective of the fact whether or not there is a formal handing over the property to the waqf or not, which is known as waqfnama. So in absence of waqfnama also, if the property was used for a longer period of time for such purposes, that is charitable and religious purposes, they were deemed to be a waqf property. Now this will be done away in the current act which has been passed by the Parliament, which means in absence of a particular waqfnama, you can't use that property as a waqf property, right? So this does away with the concept of waqf by use, that is the 2025 law. Now suppose if there is this old mosque or old religious charitable institution which is continued to be used as waqf, but they do not have a waqfnama, so technically they have to stop using that property as a waqf property. Now the government argument to introduce such provisions, that is doing away of waqf by use, is that many cases the land were encroached upon in the name of waqf, making it necessary for it to remove such use of provisions which were used rather wrongly to encroach upon a private property. So this was the rationale given by the government to introduce or to do away with waqf by nama. Now this moves raise question on status of several waqf by use properties which have long contained mosques or graveyard, but they do not are registered as waqf and do not have a particular kagas or a particular piece of paper that highlights that this property has indeed been transferred for the use of waqf. Now petitioners have argued that by nature waqf by use lands are difficult to register. How can you register a particular land that has been in use for 300 years as a mosque, right? So this is the arguments of the petitioners. Now another key issue is the power of district collector. Now we understand whenever there is a dispute whether this property belongs to government or this property belongs to waqf. Earlier this matter was dealt by waqf board and eventually by the waqf tribunal. Now this matter will be decided upon by the district collector, that if the matter is under question whether this land belongs to waqf board or this land belongs to government, this will be discharged by the district collector, and the petitioners feel that when district collector is itself is an employee of the state, that is of state government, so how can district collector be impartial in his or her decision, right? So therefore the conflict of interest is one of the key issues that the petitioners have highlighted. Now if the district collector identifies land currently used as waqf government land, then it ceases to be a waqf land till the court decides on the dispute. So the petitioners also have the problem that it is the responsibility of the court to decide on the dispute. So how can the status of this land change even before the court has decided on this matter, right? Similarly, there is also an issue relating to inclusion of non-Muslims in the waqf board. Earlier only Muslims were allowed to be the members of waqf board. Now government has added at least 3 members who can be added to the waqf board, including the non-Muslim CEO. Now the petitioners have actually said that by appointing non-Muslims to waqf board, it is actually violative of article 26b, 26c and 26d of the constitution. 26b actually provides minorities the right to manage their own affairs in matters of religion. 26c actually provides the right to minority to own and acquire movable and immovable property, and 26d actually provides the minority the right to administer such property in accordance with the law. So according to the petitioners, all these three rights are violated when you are appointing non-Muslims to the Waqf board. Now, the centre has argued that allowing non-Muslims actually will not affect the veto right of the community because these are in minority numbers. So eventually the right to make decision is eventually will be rested with the Muslim community and Muslim members only, right? And also it will allow the members or experts to be added to the Waqf board who will actually administer these property in expertise, right? Now the petitioners have held that even one Muslim is too many and it is not acceptable to them. Now, also there is an issue related to applicability of Limitations Act. Now, Limitation Act is an act passed by Indian Parliament which bars parties from making a legal claim on any property after a certain period, which was 12 years. So, technically, you can't say after 12 years that this property belongs to me. The courts will say, what were you doing for 12 years, right? So, this 95 Waqf Amendment Act specifically excluded the application of Limitation Act, which essentially allowed the challenge of claims of any property even beyond the limitations posed by the Limitation Act, right? Now, this 2025 laws actually allows that Limitation Act is also applicable on Waqf board. So, beyond a certain time, you can't claim such property to be disputed, right? So, this is the key issues relating to the application of the Waqf Act. Now, this act is currently being considered by the Supreme Court. So, whenever Supreme Court gives its judgment, we will also cover it in our discussion. So, this also eliminates or ends our today's session. The notes will be available on my Telegram channel ATS Live. So, please download it. Also, these our today's session specifically include many important discussions. So, please revise them. And if you have any doubt, please feel free to ask me in the comment section or even in the Telegram channel, right? So, I'll see you again tomorrow at 4. Please have a very pleasant evening and a very good night.